Good afternoon. My name is Alex Carlin. I would like to go on the record and to call this adjudicatory proceeding to order. I'd like to welcome the representatives of the parties. Mr. Lutz, can you hear us?
Yes, thank you.
Very good. And the representative of the applicant and the staff. We'll have introductions in a moment. But for now, I want to go through the initial formalities. We're here to conduct an oral argument in the matter of Southern California Edison Company. And this matter involves a challenge to Southern California Edison's application to amend its license and to change some of the technical specifications in its license for the two nuclear power plants or reactors that are located in San Onofre, California. The docket number of this proceeding is 50-361-LA and 50-362-LA. Those two numbers reflect the fact that there are two separate licenses and two separate reactors. The ASLBP number is 12-932-01-LA-BD01. And this proceeding is being held pursuant to an order that this board issued on November 20th, calling for an oral argument. Today's date is December 5th, 2012, and the location for this oral argument is the Atomic Safety and Licensing Board panel's hearing room in Rockville, Maryland, where the representatives of the applicant and the staff are here in person, and the petitioner, Mr. Lutz, for Citizens Oversight, Inc., is participating via video conference link out in San Diego, California. First, I'd like to introduce the board. To my right is Dr. Anthony Barata. He's the Associate Chief Judge, Technical of the Atomic Safety and Licensing Board panel. He is a PhD in nuclear engineering, former professor and chair of the nuclear engineering program at Penn State, and he came also out of the Naval Nuclear Engineering program of the U.S. Navy. Nick Trikouros on my left has a BS, MS, and an engineering degree at Polytech University. He has over 30 years of experience in the nuclear industry with senior positions with the GUP Nuclear Corporation, and he was involved and is one of the early responders at the 3 Mile Island Unit 2 incident. He's also been an adjunct professor at Rutgers University. My name is Alex Carlin. I'm a lawyer by training, 30 years in practice of law and 8 years of being a judge on the ASLBP, and so I serve as the chair of this board. Other members of our staff who are helping us on this matter, Ms. Nicole Picard, to my left, is a lawyer and a law clerk for the board. Ms. Tawana Ellis is here, I believe. If you raise your hand, she's administrative assistant that helps us on matters. Mr. Joe Deutscher is an IT specialist who I believe is out there in San Diego with Mr. Lutz, helping arrange the video link. Mr. Scott Burnell, I believe, is here. Mr. Burnell over there. He is with the Office of Public Affairs of the NRC, and if any media representatives are here, he would be able, hopefully, to respond to any questions you might have. Next, I'd like to thank the United States National Labor Relations Board for allowing us to use their premises, their offices out in San Diego, to video link Mr. Lutz and the Citizens Oversight members in. In particular, Mr. Steve Sorensen, who is a resident officer, as I understand it, out there, and Olivia Garcia, who is the regional director, who helped us with this, and Jennifer Kovacic, who is an attorney who has been very helpful with getting it set up. Now I'd like to turn this and ask the parties to introduce themselves and their members who may be with them, and perhaps we could start with Citizens Oversight. Mr. Lutz, could you introduce yourself and your team, please?
Yes, thank you. My name is Ray Lutz. I am the National Coordinator for Citizens Oversight, which was founded in 2006 and since incorporated in 2011. And what we try to do is to increase the oversight of government at all levels. I have with me here Martha Sullivan, and she is formerly with the California Public Utilities Commission. 20 years at the Public Utilities Commission, so she has quite an experience with these matters, at least with regard to California and the rate base and so forth, those sort of issues. My background is that I'm a double E electrical engineer from San Diego State University with a master's degree. I've been in private industry for many years and have had my own businesses. I am not a nuclear industry, person per se, but I have gotten interested in this due to the steam generator failures at San Onofre, which have been a big concern here, as well as of course, the Fukushima accident, and so those have brought my attention to these issues.
All right, thank you, Mr. Lutz, and Ms. Sullivan, thank you. Mr. France, perhaps you could introduce the team for Southern California Edison.
Yes, I'm Steve France with the law firm of Morgan, Lewis & Bacchius here in Washington. We are counsel for Southern California Edison, or Edison, we refer to Edison during the pre-hearing conference here. To my right is Stephen Burdick, one of my associates, and then to his right is Mark Morgan, who is a senior nuclear engineer with Edison.
Okay, thank you, Mr. France. For the NRC staff, could you introduce yourself, please?
Certainly. David Roth, counsel for the staff. To my right is David Solkowski, also NRC staff counsel. And to my left is Joseph Lindell, also NRC staff counsel.
Okay, Mr. Roth, thank you. A few housekeeping matters, and we're going to talk a little bit about what this proceeding is and what this proceeding is not. But before that, just housekeeping. Cell phones, could everyone just put their cell phones on mute? And any conversation should be conducted outside in the hall. The only exception to that is Ms. Picard, who have given a special exception if we have a technical difficulty with regard to the video link. She and Mr. Deutscher will be in communication one way or the other to hopefully to identify that there is a problem and hopefully then to fix it. Second, webcast. We have arranged to have this proceeding webcast, so I understand from our technical people that webcast is operating, and we welcome members of the public who are observing this via the webcast. Third, media. We welcome the media to the extent they're watching or in the room here, I don't know. Pursuant to NRC's published rules, still cameras and video cameras need to be are welcome, but need to be in a stationary position and need to only use natural light, ambient light, and so that we don't have a disruption of the proceeding and that they don't intrude on our discussions. Next, I'll note that we are having a transcript made of this proceeding, and that transcript will be posted on the NRC's website, the electronic hearing docket, within a week or two at most. Now I'd like to cover, for the benefit of the public, I think, and those who are not entirely familiar with this process, I'd like to talk about 4 points. One is the role of this board, who we are, what we do. 2 is the history of this proceeding. 3 is the purpose of today's proceeding. And 4 is a clarification of what this proceeding is not. And because there's a lot of things going on with regard to the San Onofre nuclear power plant, we need to make sure that people understand that we are only part of the picture. So first, the role of the Atomic Safety and Licensing Board. The 3 of us are members of something called the Atomic Safety and Licensing Board panel, a panel of a number of judges, 20, 30 judges, and we were selected as the 3 to serve on this board to make the rulings in this case. Federal law, the Atomic Energy Act, charges the Nuclear Regulatory Commission with regulating civilian nuclear facilities in the United States. And so we're part of the NRC. If you think about it, one way to think about it is the NRC has sort of three branches: the commissioners, the NRC staff, and the Atomic Safety and Licensing Board panel. The commissioners, there are 5 commissioners. Those are the executive branch of the NRC. They run the show. They're appointed by the president. They're confirmed by the Senate. That's the executive function. The NRC staff. The commissioners have a large regulatory staff working for them and working to review applications, to process environmental impact statements, and the people in the NRC staff are currently reviewing and processing Southern California Edison's application to amend its license. And so they serve as the administrative arm, one way of thinking about it, at the NRC. The Atomic Safety and Licensing Board role is significantly different. We have a judicial, quasi-judicial role. We rule upon cases that come before us, challenges that come before us that are raised by an intervener, a citizens group, a state or local entity, challenging something that the staff and or the applicant are trying to do. And our job is to rule on those challenges. And that's what we're going to try to do here today. Under the law, I'm going to talk about communications a little bit. The Atomic Safety and Licensing Board sits here in the building of the Nuclear Regulatory Commission. But as a matter of communications, under the law, it is prohibited for the NRC staff to have any communications with us about this case, and it's prohibited for any of us to have any communications with the NRC staff about this case. The only exceptions are communications that are made here in this open courtroom, hearing room, or communications that are filed in writing that all the parties can see, and the public for that matter, and non-substantive communications such as trying to schedule a time and a date for this hearing and finding out if some of the people are available or not. Logistics, I'll call that. Likewise, this board is separate from the 5 commissioners of the NRC. They're not allowed to talk to us about this case, and we're not allowed to talk with them about it, and we don't. They don't conduct performance reviews on us. They can't dock our pay if they don't like our decisions. They can't give us a bonus if they like our decisions. We don't get performance reviews, and we don't talk with them, and they don't talk with us. We try to call these cases as we see them, and if somebody doesn't like it, well, they can appeal to the commissioners, and the commissioners can either reverse us or affirm us, but we don't talk with them either. Now, all those rules are supposed to be there to help us be independent and impartial, and that's what we endeavor to do, and we believe we are. And I just want the public to understand that, because when we talk about the NRC, there are really 3 entities, and one of those entities is the NRC staff, who is sitting here in front of us today, and we're the adjudicatory board. Finally, I would add, with regard to the communication rules that I just described, the same rules essentially apply to the applicant and to the intervener. Obviously, we cannot talk with the applicant or the intervener. They can't talk with us. The only communications that are available are in open court, in written form that are open to the public, or logistical emails like how to set up this video conference with Mr. Lutz and that sort of thing. That's the role of the ASLBP. The second is a brief history of this proceeding, this specific proceeding. On July 29, 2011, Southern California Edison filed a license amendment request with the NRC staff. The staff, about a year later, in August of this year, published a notice in the Federal Register saying that they had received this application and giving the public 60 days within which to file a petition to intervene and request a hearing to challenge it. On October 17th, Citizens Oversight filed a request for a hearing, and in that request they also included 3 contentions, and we'll talk about contentions a little bit later. And a lot of our discussion here today will be asking questions about those contentions. After they filed the petition for hearing, the staff and the applicant filed answers to and they ask us to deny the request for hearing. And then Citizens Oversight filed a reply on November 16th. Meanwhile, on October 25th, pursuant to the commissioner's order, Roy Hawkins, the chief judge of the Atomic Safety and Licensing Board, created this board and nominated the three of us to handle this case. So we came into existence, this board, on October 25th. And after we read all the pleadings that were submitted by the parties, we realized we had some questions that we thought if we got some answers that would help us rule on this request for hearing. So we scheduled this oral argument. We issued an order on November 20th scheduling this oral argument. So that's the history of this proceeding. The purpose, the third item, the purpose of today's proceeding, the purpose is for us to decide whether or not to grant or deny the request for hearing that was filed by Citizens Oversight. This is not the hearing. This is a preliminary decision as to whether the hearing should be held at all. If it is, there will be an evidentiary hearing where witnesses come in, exhibits are presented, people testify, people ask questions, and we have a full trial. But right now we're just deciding whether or not to have a hearing. As we've read the pleadings, three issues seem to have developed in the pleadings of controversy. One is whether Citizens Oversight's petition is timeliness. Second is whether Citizens Oversight has shown that it has standing to file this petition. And third is whether it has filed any contentions that are admissible under the NRC's rules for admissibility. And so we're going to try to decide those issues. We're going to ask some questions about those issues. Most of them, I think, are going to focus on the contention admissibility, but there may be some questions on the other points as well. Timeliness, standing, and contention admissibility. As to contention admissibility, the regulations that govern us, that govern this proceeding, are the law. We are bound by those, and the regulation 10 CFR 2.309F provides the criteria for deciding whether a contention is, quote, admissible. And those criteria include things like whether the contention is within the scope of the proceeding, whether the contention is material to the proposed license amendment, whether or not the contention provides a, quote, concise statement of the alleged facts or expert opinions which support, close quote, the contention. So those are the things that a contention has to meet in order to be admissible, and we're going to ask some questions about that. After today, we'll issue a decision on whether or not to grant or deny the petition for hearing. If we decide to grant a hearing request, then the hearing will be held sometime later, several months from now, presumably at least. If we decide to deny the hearing request, then that's the end of the proceeding. Subject to appeal to the commission itself, who can reverse us, or if you don't like that, you can go to the federal courts and they can reverse us, the Federal Court of Appeals. So that's what we're here to do. Fourth, I want to clarify what this proceeding is not. There's a lot of activity, apparently, that's going on with regard to the San Onofre nuclear units 2 and 3. All I know is what I read in the newspaper. I'm like Will Rogers. I'm not privy to anything going on there, but I do understand that in January 2012, Unit 2 or 3 was shut down. Currently, both of the units are shut down. There are issues related to the steam generators that are experiencing some sort of wear. And in March of this year, 2012, the NRC staff issued a confirmatory action letter to the Southern California Edison about the steam generators and that sort of thing. October 9th, 2012, the NRC staff and Edison conducted a public meeting about, I think it was about the restart, and a lot of people attended, and that was a lot of interest there. November 30th, staff and Edison conducted another public meeting, and there was a lot of discussion there. That's not what we're here to do. Meanwhile, back at the ranch on June 2012, another entity called Friends of the Earth filed a separate request for an adjudicatory hearing. They asserted, I believe, that, and it's public record, that among other things, the confirmatory action letter was a de facto license amendment, and they requested to have an adjudicatory hearing on that, related to that confirmatory action letter and the restart of the Sun and Free facilities. In November 8th, the commissioners issued an order ruling that a board should be created to deal with the Friends of the Earth request for a hearing. On November 19th, such a board was created. It's a different board. It's not us, different board entirely. I might say that Judge Barada, Dr. Barada, is on both boards, but it is a different entity, and we're not here to deal with that issue. So we're not involved in those. Those are not within our jurisdiction. Our role is limited. Our role is limited to the situation that Edison has applied to the NRC to amend its technical specifications. Citizens Oversight has challenged some of those proposed amendments, and they've requested a hearing, and that's what we're here to talk about. Any additions you have, Dr. Brown?
No, I have none.
Okay. All right, I want to talk about format before we get started. This proceeding today will break down into 3 basic parts as specified in a November 20th order. First, we'll have opening statements from each of the parties, 10 minutes each. We'll start with Citizens Oversight, then we'll go to the Southern California Edison, and then we'll have the NRC staff in that sequence. Next, we'll go into what I would say the meat of the proceeding, which is questioning by the board. We will ask questions of the lawyers and representatives of the parties about what they've pled, what their documents say, and help us understand what's going on here. And we'll break that down probably into the 3 contentions, so we may break that down into 3 different sections. I think we only have major questions on 2 of them, 2 of the contentions, so it may break down just to 2 main questions, main set parts of the questioning. And then the third part of our entire proceeding today is closing statements. Everyone will get about 5 minutes to give a closing statement in the same sequence as before. As to logistics, for the people here in the room, please use the podium when we're called upon you for oral argument. Only one authorized representative for each party may speak on this issue. If the video link becomes pixelated, Mr. Lutz or Mr. Deutscher, Ms. Sullivan, someone needs to let us know if you can't see us or if something's going wrong out there. And if that doesn't work, we'll try to fix it. Just let somebody let Nicole Picard know that there's a technical problem they experienced. We will probably take a break in about an hour and a half. We think this maybe go a couple hours, 3 hours, we don't know. Could go a little longer. Finally, I also want to note that we received an addendum. Citizens Oversight filed an addendum on Monday, I believe it was, to its reply brief. And Edison filed a motion to strike that addendum, saying it was inappropriate. We're just going to hold that in abeyance today. We're not going to rule on that. We'll rule on that when we ultimately rule on all of the issues here, but we're just going to hold off on that. So with that, we're going to go to opening statements, but first I'll ask if the parties have any questions or additional issues they think we need to put on the agenda here today. Mr. Lutz, maybe I'll start with you. Anything additional?
No, I'm fine, thank you.
All right, thank you. Mr. France?
We have nothing.
Okay. Mr. Roth?
One procedural item, Your Honor. With respect to one designated representative speaking, it was unclear from the board's order that that was going to be the case. And if it may please the board, we would actually like to have the opening presented by Mr. Solkowski, and the closing will be Mr. Lindell, plus any questions for Standy, and the actual contentions will be me.
Does anyone have any objection to that?
No, and in fact, we plan also to divide up the argument with myself taking contention 1 and the opening statement, then Mr. Burdick taking issues on timeliness, standing, and contentions 2 and 3.
All right. Mr. Lutz,
I
you there?
Yes, hello. I know we were told that we could only have one person speaking. I think it's only fair that these other parties are held to the same restriction. We were told that we could have a maximum of 3 people here. We were able to get Ms. Sullivan to come, and she's been very helpful. But if we're going to be held to only one person speaking, we'd like to request that the other parties have the same restriction.
If it may please the board, David Roth for the staff.
Yes.
The staff would have no objection if Mr. Lutz's other designated representatives also wish to speak.
Well, we did say 3 for each, and there's 3 for the applicant, 3 for the intervener, 2 for the intervener, and then 3 for the staff. I think we're going to I'd say this, on the oral argument, we only want one lawyer to appear for the oral argument on the answering of the questions. For the opening statement and the closing statement, you want to put somebody else up for that, that's okay. All right? Okay, we're going to start with opening statement by the intervener. That's Mr. Lutz. You have 10 minutes, sir.
Okay,
We're all ears.
thank you very much, and I want to thank everyone and your courtesy in getting this set up. Everyone has been extremely courteous, and we really appreciate that. I've already introduced myself, so I'll skip that part. Again, we're organized to improve oversight of our government at all levels. We quickly discovered that most governmental bodies have insufficient public oversight, and this can frequently result in waste, fraud, and abuse. The steam generator failures in Fukushima is an example of waste. We learned over the course of the past 6 years that there is a tendency for these organizations to innocently reduce public participation over time. There are 2 distinct avenues for public participation. The first being opportunities such as this, which are spelled out by the law. Secondly, the public can participate outside the scope of the regulations, but as specifically supported by our democratic republic form of government. To be effective, the public must carefully monitor the activities of the governmental body, and if it's not performing its duties, even if it's following every letter of the law, the public can, through their elected representatives, modify the regulations, open official congressional hearings, or issue executive orders, for example. Essential to the effective involvement by either avenue is a government or agency that is transparent and welcomes monitoring by the public. President Obama on January 21, 2009, first day of his administration, issued a memo entitled Transparency in Open Government, which promoted that, and paraphrase, government should be transparent, government should be collaborative, and government should be participatory. Public engagement enhances the government's effectiveness and improves the quality of its decisions. Knowledge is widely dispersed in society, and public officials benefit from having access to that dispersed knowledge. Subsequent to that initial action, the President issued Executive Order 13579, which I think is the most odd number you can think of, but it's on July 14th, 2011, and it explicitly provided for members of the public to participate in independent agencies such as the NRC. Quote, wise regulatory decisions depend on public participation and on careful analysis of the likely consequences of regulation. Such decisions are informed and improved by allowing interested members of the public, and I want to underline that phrase, interested members of the public, to have a meaningful opportunity to participate in rulemaking. Indeed, the NRC states that it embraces the concept of openness and transparency. You can read on the website. Yet, the NRC has a long-standing practice of limiting oversight by the public, and this is in fact the underlying dispute of our contention number 1. The culture of suppression of public participation was initially founded on reasonable decisions to improve efficiency by reducing the number of hearings and the associated costs and time delays. But it has, in the view of COPS, that's my organization, Citizens Oversight, we refer to that occasionally, evolved into excessive suppression, which has resulted in serious errors and placing the safety of the public at risk, and must be discontinued. Specifically, A, the NRC directly limits public participation through a difficult gauntlet of requirements, such as adopting very restrictive definitions for standing, such that petitioners must have a very specific interest in the proceeding and not just be interested as stated in the executive order. By reducing the window for participation to the absolute minimum, the current proceeding includes 14 volumes of information, each with over 500 pages, and was processed for over a year by the licensee, yet the public has only 60 days to study it and respond in detail. And 3, by strictly enforcing arbitrary submission formats and detailed requirements, which we're going through today. B, secondly, the NRC limits the number of proceedings which are available for participation by reducing the number of license amendments which are processed. One way this has been done is by moving critical information into licensee-controlled documents, so there is very little left in the core license that will ever be changed. This, in fact, is the subject of this petition to intervene, because the surveillance frequency specs must not be removed from public review. Thirdly, the NRC interprets 10 CFR 50.59, the like-for-like rule, extremely liberally, such that almost no change rises to the level that requires a license amendment and therefore possible public participation. The recent steam generator failure at the San Onofre plant brings this issue to light, because Edison admitted that, quote, a major premise of the steam generator replacement project was to avoid NRC approval, unquote, meaning that they strove to avoid the license amendment process. So that, in summary, is our concern overall. Now, regarding contention 1, and your request for us to compare that with 10 CFR 50.36, the technical specs, COPS claims that this is a valid contention. NRC regulations that I mentioned includes the following provisions under C, technical specifications, will include items in the following categories. Under subsection little I, safety limits for nuclear reactors to reasonably protect the integrity of certain physical barriers that guard against the uncontrolled release of radioactivity. Then under little I2, automatic protective devices related to those variables having significant safety functions, and I omitted some words. So in essence, these provisions provide that the safety specifications must include a first set of safety limits which must not be exceeded to reasonably prevent the uncontrolled release of radioactivity, and a second set of safety system settings for automatic protective devices, which must be ready to operate in the case of an accident scenario starts to unfold. For purposes of this analysis, these will be called Class 1 and Class 2 respectively. In practice, these safety limits are with respect to physical parameters that can be measured. The safety limit consists of A, a value that can be measured, and B, a requirement that the measurement must be made on a regular basis and compared with the safety limit. If either or the existing limiting value does not exist, or it's never measured, then there would be no limit. A surveillance requirement consists of values to be measured, which are called surveillances, and a maximum time intervals, which are called surveillance frequencies. The licensee has proposed a great many surveillance frequency specifications be moved out of view from the public and into licensee-controlled documents. But these safety limits are in the Class 1. That is, if they're not respected, the reactor can move out of the safe operating limits, and an uncontrolled radioactivity release can result, and therefore they must not be moved out of the technical specifications. To make this point perfectly clear, we can consider Attachment 1, Volume 7, Chapter 3.4, Reactor Coolant System. If you have the amendment that I sent, you'll be able to look at that easily. There are over 50 critical parameters that are proposed to be removed from this one section alone. This section of the technical specifications deals with a system which is completely within the containment building and deals with the critical cooling system of the reactor. If this system does not operate as specified, then a devastating accident can occur. The plant can begin to overheat and quickly degrade into a loss of cooling accident, or LOCA. Such accidents are one of the most important types of accidents to avoid. For example, consider specification 3.4.4.1 on pages 88, 89, and 95 of the submitted document from Edison, which is to, quote, verify each RCS loop is in operation and the frequency is 12 hours. In NRC regulations 10 CFR R50.46 called Acceptance Criteria for Emergency Core Cooling Systems for Light Water Nuclear Power Reactors. Emergency Core Cooling Systems, or ECCS, are required to be designed so they can cool the core in the event of a postulated locus. This further underlines the critical nature of a reactor cooling system in general, such that we can clearly place the inspections on the system within the Class 1 requirements of 10 CFR 5036. Therefore, these critical operating parameters must remain in the technical specifications, and therefore contention 1 is valid. The NRC is therefore obligated to grant the request for a hearing by COPS in the matter. This request for a hearing is not a, quote, hearings for hearing's sake, unquote, as mentioned in the decision by CLI 01-24 back in 2001. In fact, we object to the notion that public hearings are without value, even if the agency may view them that way. The article called Nuclear Licensing, Innovation Through Evolution and Administrative Hearings by B. Paul Cotter, Jr., from the Administrative Law Review, written in 1982 and referenced by CLI 01-24, states in the conclusion, quote, the simple fact is that a case cannot be made that hearings obstruct development of nuclear-generated electrical energy. The gravity and complexity of the issues concerning the public health, safety, and welfare and the use of commercial nuclear power warrant the rigorous discipline of adjudicatory resolution. And I hope the members of your body agree with that, since that's your job. Now, I'm going to not go on with other details. I know you have some questions about the things that we want to go on with. I've just about used up my 10 minutes, but I hope that puts into some perspective our point of view as to why we must go forward with the hearing. Thank you.
Thank you, Mr. Lutz. Mr. France, please, if you would, at the podium. Good afternoon. I'd like to thank the board for having this pre-hearing conference. At the outset, I'd like to note that there is a defect that permeates almost all the petitions intervened. The license amendment request at issue here is very narrow. All it seeks to do is convert our current tech specs to the improved standard tech specs. But because it has a relatively narrow scope, the permissible contentions also should have a very narrow scope. In contrast, most of the petitions intervened goes well beyond the scope of our license amendment request. Contrary to the apparent belief of COPS, this proceeding is not here to raise allegations in general regarding operation of the plant, regarding the general adequacy of our tech specs, the current tech specs that are not being changed in some respects, or to discuss restart of the plant following corrective action for our steam generators. And Judge Carlin, I believe you yourself recognized that in your opening statement. More specifically, as discussed in our answer to the petition to intervene, we believe that the petition to intervene is defective on 3 primary grounds. Discussing timeliness first, the Federal Register clearly identified a deadline for filing petitions to intervene. COPS concedes that its petition was filed late. The only excuse it has is that it misread the Federal Register notice. Well, naturally, misreading of a legal notice is not a sufficient basis for a good cause for a late filing. Second of all, COPS has not established standing to intervene in this proceeding. COPS relies upon Mr. Lutz and his location allegedly near the plant for representational standing. However, in license amendment proceedings, the mere proximity to the plant alone is not sufficient to confer standing unless the amendment in question has some obvious potential for off-site radiological consequences. In this proceeding, COPS has not identified any such obvious off-site potentials given our license amendment request. And therefore, there is no proximity presumption for standing in this proceeding. In any event, even if you assume that there is a presumption of standing based upon proximity, Mr. Lutz does not satisfy that presumption. He lives more than 50 miles away from the plant, and therefore he does not have sufficient proximity to confer standing. I might also add he does not have any other valid allegations of any interest affected by this proceeding to confer standing. In an attempt to cure some of these defects, the reply by COPS identifies other members who do live, reportedly,
within 50 miles of the plant. However, they have not provided any affidavits from any of these members that show that the members have agreed to have cops represent their interests in this proceeding. So in summary, they have not established a representational standing. Third, COPS has not submitted at least one admissible contention. The three proposed contentions have numerous deficiencies. I'd just like to highlight a few of those. Contention 1 argues that we should not be able to remove surveillance frequencies from the tech specs to a licensee controlled document. And contrary to Mr. Lutz's allegations, we aren't proposing to remove any critical safety parameters to a licensee controlled document. We aren't proposing to change the limiting safety settings, safety limits, or the limiting conditions for operation. We aren't even proposing to change the surveillance requirements. What we are proposing to do is change the surveillance frequencies and move those into a licensee controlled document. And there is nothing in 50.36 of the regulations that precludes such an amendment to the license. In fact, a number of other plants have already gone through this process, and the NRC has approved removal of their surveillance frequencies to a licensee controlled document. COP's primary argument here is that relocation of the surveillance frequencies will deprive the public of their right to oversee changes to those frequencies in the future. However, the Commission has dealt with a very similar issue previously in the Millstone proceeding, which the board referred to in its order. And the Millstone decision clearly indicates that a mere relocation of a provision from the tech specs to a licensee controlled document does not provide a sufficient basis for contention to intervene. Contention 2 largely consists of complaints about provisions in the current tech specs, not the proposed tech specs. In a license amendment proceeding, however, a petitioner cannot complain about the current tech specs. It's limited to making contentions regarding the proposed changes in the tech specs. I might also add that COPS has, I think, mischaracterized many of these changes. They are not changes vis-a-vis the current tech specs. They are changes versus the improved standard tech specs. In some cases, we've decided not to adopt the improved standard tech specs. And almost all of its complaints pertain to cases where we've chosen not to go from the current tech specs to the improved standard tech specs. Since it has simply misconstrued our application on contention 2, that contention is not admissible. And contention 3 complains about the steam generator repair and possible restart of unit 2. Again, as Judge Carlin indicated, that issue is outside the scope of this proceeding, and therefore that contention should also be dismissed. Again, thank you, Judge Carlin and the rest of the board for giving me this opportunity to make the opening statement, and I look forward to answering your questions later on.
Thank you, Mr. France. Mr. Solkowski?
Yes, sir.
For the staff.
Yes, Your Honor, thank you. Good afternoon. Again, my name is David Solkowski, and with me at council's table are Mr. David Roth and Mr. Joseph Lindell. And today, the NRC staff is prepared to discuss why COPS has not met its pleading burdens and established an admissible petition to intervene, or why the petition to intervene should not be granted. Namely, for 3 reasons. First, the petition is filed after the deadline, and COPS has not demonstrated good cause to cure the failure to file after the deadline. Second, the petition fails to establish standing for either Mr. Lutz himself or COPS on an organizational standing level. And third, the petition fails to establish any admissible contentions. On the first question, timeliness, the petition should be denied. First, because it was filed after the deadline. That deadline was explicitly established in the Federal Register notice, noticing this license amendment. At the head of the Federal Register notice, the deadline was established as October 15th, 2012. The petition came in October 17th, 2012, after the deadline. In its reply, COPS offers as a reason for the failure to file by the deadline that it was misinformed about the deadline, or perhaps that it misread what the deadline was. The NRC has regulations for admitting contentions that are filed after the deadline, and misreading the deadline is not one of those options. The option is to establish good cause for failure to file after the deadline, and COP's petition and COP's reply do not establish good cause. On the question of standing, the petition should be denied because Mr. Lutz's citizens' oversight is not covered by the geographic proximity presumption, that standing presumption, given that Mr. Lutz does live more than 50 statute miles from San Onofre. And in any event, the geographic proximity presumption does not apply to license amendment proceedings where there's no obvious potential for off-site radiological consequences. And the petition does not establish that obvious potential either. And finally, none of the three contentions presented in the petition are admissible. Each contention suffers from legal deficiencies, such as lacking an adequate factual basis, or in many cases being outside the scope of this license amendment proceeding. The NRC staff submits that the pleadings in this case demonstrate that citizens' oversight has failed to meet its pleading burdens, and accordingly, the board should deny the petition. Thank you.
Thank you.